Hello, good afternoon if you're on the East Coast, and good morning yet if you're way out west, whether you are in St. Augustine, Florida, Rockford, Illinois, or Honolulu, Hawaii. We are glad you're here. My name is Lacey, and you are listening to the Higher Education Regulatory Outlook for 2022, which is part of the Higher Education webinar series offered on an annual basis by the law firm of Thompson, Coburn, LLP. I will start out, as always, here with a few housekeeping items while folks are still joining. If you have any questions during the webcast, you can submit them through that Q&A widget at the bottom of your screen, and I hope you will. We've been deliberate about building in some time for questions. I think there's a lot of interesting ground to cover today. So if you do have a question about the regulatory environment or what's happening or has happened or what may be coming down the pike, please drop it in and we'll try to get to them. I also will point you to the resource widget there where a copy of today's slide deck is available. As always, we encourage you to download that resource. If for some reason you can't get it, you can certainly email us as well anytime. You can find additional answers to some common technical issues located in the Help widget at the bottom of your screen. For those of you who may be attorneys signing on for CLE, the webinars are credited today for CLE in California and Illinois for an hour and a half of general CLE credit, and in Missouri for 1.8 hours of general CLE credit. Also, it's accredited in New York for an hour and a half of experience and transition credit, and we've got an hour and a half of general CLE credit pending in Texas. We always award CLE based on attendance for the entire 90 minutes, so do please be sure that you stick around for the full 90 if you're seeking CLE. Also, due to changes in some jurisdictional requirements, you will notice during the presentation that we're no longer using the little automated pop-up attendance checks that we used to use. Instead, we will be displaying secret words. And those of you who've been around long enough and following us long enough will recall that 2 or 3 years ago we actually used to do the secret words. So we'll display secret words today, which will have multiple choice polls during the webinar. I think there are 3 of them that will pop up, and we will need you, if you're looking for CLE credit, to make sure that you catch that when it pops up and complete the multiple choice question. So again, please respond to those polls to demonstrate your continued engagement and make sure you earn all of your CLE. Finally, we always have a survey at the end of the presentation, and I'm always very grateful for any feedback you all can offer. We do review the surveys and take your feedback very seriously, and always try to make sure that the next presentation is better than the one before. So with that having been said, let's get moving. There's our Q&A, which I should have gone to the housekeeping slide, so we'll skip that and go straight to a little bit about the firm. There are always a few new folks on, so just to be clear, we are a law firm, Thompson Coburn. We have a little over 400 attorneys with offices around the country, including a newish one in New York, the Big Apple, and we're glad to have those guys on board. And this presentation is being brought to you by our higher education practice. So we have attorneys within our firm who either full-time or for a significant amount of the time provide counsel and services to institutions of higher education. And that really, those services run the gamut from sort of compliance and training to legal and litigation. And we do a lot of merger and acquisition work here, actually, as well, involving strategic transactions between all different kinds of institutions of higher education. The only presenter today, so you're stuck with me. I'm the chair and a partner in the higher education practice. My name is Lacey. And as some of you know, when we do regulatory topics like this is really my bread and butter, as they say, and I'm always deeply involved in and interested in these topics. So I will be the person today who sort of walks you through what's been going on in the space. Here is our syllabus. We'll start with just a couple of comments on our newish department, not brand new anymore. They've been around about a year. And then the bulk of the presentation, we're really going to focus on the department's regulatory agenda, which is broad, sweeping, aggressive, impressive in many ways, and also very much on the move. There were fairly significant developments just late last week, Thursday and Friday of last week. I'll offer up a few observations concerning some additional machinations that have been emanating from inside the Beltway. And then finally, I'll spend a little bit of time focused on the rulemaking that just completed its 3 rounds of negotiated rulemaking meetings last week. That's, I'll call it the ASL rulemaking for short. In a minute, I'll tell you what that acronym means. And then we're going to talk even a little more briefly, but in focus, on that borrower defense rule that those of you who are regular listeners have heard me chat about before. And finally, I'll walk you through a little bit of TC extra credit. All right, so let's first talk about the Newish department. I don't want to go on about this for too long, but it's actually relevant to the conversation we're going to have today about sort of the regulatory agenda and some of the things we're really seeing coming out of the department. Of course, Miguel Cardona was confirmed March 1st, 2021, earlier this year, as our new Secretary of Education. And like many of our more recent Secretaries of Education, his real strength and background has largely been at the elementary and secondary level. And of course, after his appointment and throughout the course of this year, we have seen a number of positions filled, particularly at that sort of political and policy level. There's always a little bit of turnover at what I'll call the staff or bureaucratic level, but it's really at the political and the policy level where you have lots and lots of turnover. Most folks from one administration will leave when the new administration comes in. And I just wanted to highlight a few of the folks who have come in and why. So, for example, Ben Miller is a senior advisor to the chief of staff over at the department, so someone who's very well positioned to have some very meaningful input. Ben was with the department previously under the Obama administration, at which point he was an advisor. And then in the interim between that administration and the Biden administration, he was a vice president for post-secondary education at the Center for American Progress. And Ben was very involved, among other things, in the gainful employment rule from 2014 and sort of its design and architecture. Mr. James Cavall, who's our Undersecretary of Education, which is the senior most position really over post-secondary education at the department, reporting directly to Secretary Cardona. He was previously at the Institute for College Access and Success and a deputy director of the Domestic Policy Council with the Obama administration, and was even at the department previously as well. Worked with Ben, was also someone who was very involved with the creation of the gainful employment rule and many other policies at the department during the Obama administration. A couple of folks who are newer, in this case to the department, but have certainly been around government. Richard Cordray was formerly the chief operating, or now is the chief operating officer of Federal Student Aid, was previously the very first director of the CFPB, and before that was an Attorney General of Ohio. And just as an example, we've got Toby Merrill, Deputy General Counsel, so a presence in the General Counsel's office. It was actually the founder and a director of the Project on Predatory Lending at the Legal Services Center at Harvard Law School, which, and this is its mission statement, represents low-income student loan borrowers in litigation against for-profit colleges and against the policies that enable them. You know, I mean, I've obviously cherry-picked these folks. Now, Jim Cavall is the undersecretary. I've sort of pulled out, and the chief operating officer, I guess, Richard Cordray, is also a very senior position. But I wanted to highlight Toby and Ben to some extent as well, to note that what I think we've got in the department right now with this administration, which is new, I would suggest even more so than was the case with the Obama administration, is a group of individuals for whom consumer protection is not just a central issue, but the central issue. And the reason I highlight that is because, and I want to make clear, I mean, there are lots and lots of people over at the department. I don't mean to suggest that everybody falls into this bucket. I also think that it is fair to say that most of the folks at the department who are, whether at the staff level or the policy level, consider consumer protection and borrower relief and things of that nature to be important issues. The distinction I'm drawing here is between those folks for whom those are important issues and those folks for whom those are the central issues. In other words, and this is an important point, we're talking about folks who are not educators, who don't come from education or higher education really in their background. We're talking about folks who come from, in their background, agencies and positions where their primary service was to consumers, and they think of students and borrowers as consumers, and they are very focused on relief concepts and discharge concepts to an extent that I think is different. And so what's interesting is, you know, you've got, I mean, different from prior administrations. So now you've got folks who think that way, and they're very much in the department. They have important voices, and they're influencing some of the policies and regulations that we are seeing emanating during these negotiated rulemaking processes, and I think that we will continue to see. And I'll try to highlight a couple of times today where it's interesting the extent to which a policy is so focused, and we saw that significantly, I think, in the context of the negotiated rulemaking that just occurred, and particularly around bar defense and some of the other discharge issues, where the focus is very strongly on discharge and student relief, and not so much on any of the other sort of dynamics or relationships that might be in play. All right, so moving on from our Newish department, let's talk about the department's regulatory agenda. Boy, there is really a lot going on. I want to walk you first through sort of the highlights that occurred during the year, and then we'll take a step back and think about where we are right now and the issues that are on the table. So May 26, 2021, that was early, and I will say it's worth noting, when the Obama administration came through, just due to sort of the age of President Obama and a lot of the folks that came in with that administration, there were a number of people at the department and throughout the government, but at the department in particular, who were experiencing for the first time a role in federal government, or at least at the levels that they were participating, right? So meaning these were folks who were not previously experienced federal policymakers and bureaucrats. They were new, and so they were learning. It's important to note that this time around, at least at the U.S. Department of Education, many of the people who were appointed at the early part of this year are folks who are doing a second or even third tour with the U.S. Department of Education. And the reason that's significant is because these folks are going to be able to execute on the regulatory process and processes at a greater clip. They understand where the pitfalls are. They understand the types of things that need to be done correctly. And if they are taking on a tremendous amount or they are pushing processes rapidly, they have a greater ability to do that than they probably would have when they were here with the Obama administration. And I think, we're seeing, like I say, broad and aggressive regulatory agenda from the department. And by aggressive, I just mean that they have a lot of stuff they want to do. And that they're trying to get done in the next couple of years. But you've got a group of people this time around who have the experience and wherewithal to potentially get that done. And I'm not sure that would have necessarily been the case. It certainly took the Obama administration more time to get its ducks in a row, to start deciding the types of policies it wanted to create. It really wasn't until the second term of the Obama administration that we saw a lot of the big sort of signature regulatory notions come into play, right? You think about gainful employment in 2014, right, versus 2008 when the election occurred. So it took several years for that to all really be put into place and the neg reg to occur and the rule to be promulgated in final form and become effective. This time around, we've got an administration and a department that is moving much more rapidly to execute on its regulatory priorities. And that could be for a number of reasons. I mean, one is they're better equipped to do it. Two is they feel very strongly about some of these issues and what was done by the prior administration. And three, they may have concerns about whether they will have a second term to execute on some of this, and may have felt more confident back during Obama's first term that they would have two to get everything done. So pretty early on, May of 2021, the department announced its intent to host negotiated rulemakings covering 14 possible issue areas. I'm going to show you those areas on the next slide. Or on a subsequent slide. And these, in and of themselves, each one of these issue areas are in some cases very broad and significant, and within them involve many, many different issues and complexities. So a couple months later, or 1 month later, I guess, on June 11th, the Biden administration released its first unified agenda of federal regulatory and deregulatory actions. If you are a real deal regulatory nerd, then you know what this is. Most people don't. But if you are ever interested in trying to get the earliest possible preview of what the administration is thinking about, what it wants to do from a regulatory perspective, I mean, short of knowing people who are part of the process and having direct conversations in terms of sort of a public document, the agenda is it. It typically gets published twice a year. Most of the executive agencies in the federal government participate, including the U.S. Department of Ed, and it does sort of what it sounds like it does. It outlines the goals for regulatory and deregulatory actions by the administration and provides a lot of insight into the administration's, their priorities, and also the timing that they anticipate through which they can get things done. The department indicated its expectation back in May that negotiations would begin no earlier than August 2021, with the committees meeting for up to 3 sessions, very common, of approximately 5 days each, also common, and that they would meet virtually, uncommon. So this is the first time, to my knowledge, that we had a negotiated rulemaking that occurred virtually. When I participated in 2017 in the Bar Defense rulemaking, we spent the entire first day negotiating whether or not the event should be live streamed. Because prior to that point, to my knowledge, at least at the department, a negotiated rulemaking had never been live streamed and available for viewing by the broader public. And now, of course, you know, not only are they available, but the entire event is taking place virtually. That may change, of course, when we get on the other side of the pandemic, or at least to a place on the other side where people are comfortable getting together in person again. So here are those 14 topics. And we're going to talk about these, and you're going to see them a couple more times here during the presentation. But I think it's worth walking through these right now with a little bit of deliberation and a slower tempo than sometimes I want to proceed with. Change of ownership and control process. So this administration, for the first time in as long as I can remember, and I've been following these things for a couple of decades plus, there has not really been a negotiated rulemaking that has seriously considered the change of ownership regulations. So the Trump administration tweaked a couple of things. I mean, I know there have been tweaks along the way, but the signal from this administration is that they're pretty interested in getting into changes in ownership. My understanding is that there's guidance potentially coming from the department, sub-regulatory guidance in the next couple of months that will be significant. I mean, we know from our practice and our conversations with others in the space that do a lot of M&A work in higher ed and just direct conversations with the department. We certainly know that a lot has already changed in the last couple of years with the introduction of new processes and protocols. Here they're talking about codifying some of this, I think, in regulation. It's also worth noting that up on the Hill, Congress has been talking about changes in ownership, particularly around conversions from for-profit to nonprofit, so where you have a for-profit institution of higher education that would convert. I flag this because it's not only significant to for-profit or proprietary institutions, it's also significant for private nonprofits and publics, where we have seen lots of activity among private nonprofits that are merging or consolidating in the last 3 or 4 years. We have seen public systems that have been consolidated, and we expect to continue to see that kind of activity. That all tends to be governed, and the processes through which you have to successfully proceed are the department's change of ownership and control processes. So I think, while many of you may, at first blush, say, well, this is not something I'm ever going to deal with, you never know. There's quite a bit of it happening right now, and I think it's something very much worth paying attention to. Procedures for initial Title IV certification. So the department's rethinking, what a school would have to do to get into Title IV and what it might have to demonstrate. Also potentially very significant. Standards of administrative capability, which you all know is a huge bucket. There are all types of things that you do as administrators of the Title IV programs that fall under this bucket of administrative capability, including things like cohort default rates, for example, are elements of administrative capability. State-defined processes for ability to benefit. So that's not all ability to benefit, but sort of specifically the element of the regulation that focuses on folks who want to use a, quote, state-defined process for determining whether somebody has the ability to benefit. That's been in the regulations a long time. I think there's always been a little vagary around what exactly that means and whether there are any states that really have those types of processes. Bar defense to repayment, which we're going to talk about later today, and is now on its moving into its fourth version, going through its third round of negotiated rulemaking. A lot of focus on discharges. I mentioned that earlier, so that's not surprising that we're seeing this in the agenda. Total and permanent disability discharges, closed school loan discharges, false certification discharges, and in particular a desire by the current department and some of the folks to enable legal aid providers and attorney generals and others to initiate applications for discharge, independent of whether a borrower may have filed an application, right? So sort of a dynamic change here where you're talking about allowing third parties to fill out and file applications either for individuals or even for groups. Loan repayment plans, public service loan forgiveness, a very important issue for folks who've been participating in that program. Pre-dispute arbitration and class action waivers, financial responsibility triggers and reporting requirements. So many of you will recall under the Obama administration when that rule first went into effect, it was a surprise to much of, I think, the private, nonprofit, and public college community to discover that they suddenly had to report all of their litigation to the U.S. Department of Education as part of the new financial responsibility triggers and reporting requirements. For those of you who recall that, it's on the table again. And my expectation is it changed under the Trump administration. These folks want to revisit it in the Biden administration. And my expectation is that they will want to expand these triggers and the reporting obligations again to something that is more consistent with what was required under the Obama administration. So if you're out there and you're a private nonprofit or you're a public institution, you're listening right now, and you are not interested in reporting all of your litigation to the Department of Education, please pay attention to these rules as they're being negotiated and as proposed versions come out, because that's where that is buried. Those reporting requirements are part of this topic. Gainful employment, which is another topic that previously I think was largely thought of as a for-profit or proprietary school issue, though it certainly had elements that applied to community colleges and public and private nonprofit institutions that offered non-degree programming. Those rules are again on the table. The department is calling it gainful employment, which suggests to me that they will again try to build a debt-to-earnings concept into that gainful employment phrase, which appears in the definition of various definitions of what constitute different kinds of eligible programs. I had wondered at one point if they would abandon that approach and try to find a different avenue for creating a debt-to-earnings requirement, but it sounds like they're going to stick around with gainful employment. I think one of the hot topic issues there will be how broadly that rule applies. Pell Grant eligibility. And then finally, the department was directed by Congress to implement some new changes to the 9010 statute and to create regulations that help carry out those changes that become effective for fiscal years beginning January 1st, 2023. So that's the slate. Lots and lots and lots of stuff on the agenda and to work through at the department and for various negotiators. So how has it been moving forward? Well, we'll actually take a pause here and we will do our first secret word. So you can see on the screen the first secret word, and then we would ask you to go down to the little rotary button that corresponds with that secret word and to click it to make sure that you're getting your credit. I'll give you guys 10 or 15 seconds to do so. We were chatting beforehand. Some of you know I am from Louisiana and a big LSU college football fan. And if you are a college football fan, you know that that particular program has been going through some significant changes in recent weeks. So we were chatting before the webcast actually about some of that. If you are a college football fan, I hope your team was fortunate enough to make it into a bowl game this year. And that it is a game and venue that you are excited to watch or attend. All right, we'll swig of coffee, keep moving. Okay, so on August 10th, 2021, remember the department back in May said we've got 14 different topics that we want to negotiate, but they really didn't go further than that. So they didn't say, how it was going to be broken up. They didn't request nominations or any of those kinds of things. So in August of this year, August 10th, after some public hearings and getting feedback, the department announced the creation of what they have called the Affordability and Student Loans Rulemaking. I'm calling it the ASL Rulemaking for short. And it is focusing on 9 issue areas. I'm going to show you those in a minute, including the bar defense to repayment rule. The ASL Rulemaking also is thinking about and considering prison education programs. So they created a subcommittee for that purpose. I can't recall the subcommittees were used much before the Trump administration did the bar defense rulemaking, but there were 2 subcommittees as part of that rulemaking. And I certainly think the idea has legs where there is a topic being considered that is either highly technical or particularly niche, and it makes sense to bring in folks with a high level of expertise to advise the committee, the main committee. So that's what they did here for the prison education program topic, which I thought made a lot of sense. And then the department also acknowledged at the time in August that there were 7 other topics out there that were not going to be covered by the ASL. Of that 14 they mentioned way back in May, and they said, hey, we'll probably do another rulemaking to cover these remaining topics, and we'll do it at a later date. Between October 4th and December 10th, that's last Friday, right, the department held 3 rounds of negotiations as part of the ASL rule. So they just wrapped that up last week, which, by the way, it is not coincidence that we are doing our webinar this week. We wanted to wait for those machinations, as they say, to come to a close so that we could report on them a little bit. Meanwhile, on October 4th, 2021, the department signaled its intent to establish that second rulemaking. Now, at first, in October, they just mentioned the 90-10 rule. But then on December 8th, again, last week, the department announced the creation of the Institutional and Programmatic Eligibility, or IPE rulemaking. I think the cool kids will be saying IPE this winter. So the IPE rulemaking, which will consider 7 issue areas, in particular the 7 that were not being covered as part of the ASL rulemaking. The department, so a couple interesting things. One is the department only permitted 7 days from the announcement for the nomination of negotiators. So in other words, the department last week in the Federal Register issued its formal announcement that this rulemaking was going to occur and soliciting nominations for negotiators. And the deadline for those solicitations or nominations is tomorrow, December 15th. So it's an unusually tight time frame, and down the road could provide the department a little heartburn if anyone decides to question these regulations and the process pursuant to which they were created. The department has announced it will hold the standard 3 rounds of negotiation and that will occur in January, February, and March. And also there is no indication that any subcommittees will be used this time around. Finally, on December 10th, also last Friday, the Biden administration released its fall 2021 unified agenda. So we talked earlier about the spring unified agenda that came out, as you would expect, in the spring. The fall agenda, a little late, we're certainly at the end of fall, but the fall agenda came out on Friday and had a lot of interesting information in it, once again, about where the department's priorities are and the timetables pursuant to which they expect to pursue those priorities. So here are the topics. What we've got then, we started at the beginning where the department said this year we want, or over these 4 years, we want to tackle 14 topics, right? And then what they essentially did throughout the years, they broke it into 2 negotiated rulemaking groups, right? The first was the ASL, which already has completed the 3 rounds of negotiation. And the second is the IPE, the Institutional Programmatic Eligibility Rulemaking, that was just announced. And that is going to be taking place January, February, March. So a very compressed timetable, right? A December 8th announcement, 7 days to nominate rulemakers or nominate negotiators. And then those negotiators have to be prepared to begin negotiation next month with the holidays in between. So a very compressed time frame. And this goes back, you recall the comments earlier about, this administration, I think, feeling like it can manage a lot of work. They're staffed up a little, they've got a lot of experience, and they've got significant priorities. And I think they're willing to do what they feel like they need to do to get these new rules in place before a presidential election. So the ASL rulemaking that just concluded covered bar defense, close-school loan discharges, total and permanent disability discharges, and false certification discharges. So all 4 of those, if you think about it, are about grounds upon which borrowers can seek the discharge of their loans. And borrower relief and consumer protection, again, are major priorities for many of, if not the central priority for many of the people who are over at the department right now. And then you have these other topics, loan repayment plans, interest capitalization, pre-dispute arbitration, class action waivers, Pell Grants, public service loan forgiveness. Into the second negotiated rulemaking, which will commence in January, we've got 90-10, state-defined processes for ability to benefit, certification procedures for Title IV, change of ownership and control, financial responsibility, gainful employment, and standards of administrative capability. Now, just those last 3, financial responsibility, gainful employment, and standards of administrative capability, represent extraordinarily broad topics. The Trump administration did a single negotiated rulemaking just on gainful employment. So it will be very interesting to see how the department intends to orchestrate a negotiated rulemaking across 15 days that can meaningfully cover all of these topics. Maybe it's because the department doesn't anticipate to really make that many changes, but there is no gainful employment rule on the books right now, right? I mean, the prior administration rescinded it entirely, which means if the department's going to put it back, I mean, you're talking about a significant regulatory framework that it would be proposing and that presumably the negotiators would have to evaluate. And that is one topic of the 7 that they're supposed to be covering. So, I'm very curious, candidly, about what the approach here is going to be. I mean, maybe for financial responsibility, administrative capability, some of these other topics, we're really talking about fairly minor tweaks so that, the department behind the scenes, which, of course, knows what its agenda really is, maybe they feel like it's really 6 smaller topics and 1 big topic, for example. I just don't know. But when I look at this, I think, boy, there's so much ground that potentially could be covered here. If I'm sitting where you are right now, I would certainly be interested in keeping track. By the way, I'll also make a promise to all of you right now. We're going to continue to produce. We are prepared and understand we're kissing our spouses and children goodbye, telling them we'll see them in 2023, and our practice is fully committed to following these and producing a lot of content and coverage next year. So we expect to be talking about the proposed versions of both of these rules when they come out, in part because we want you all to be able to file comments if you want to. And if we can assist you in understanding where issues are or things that you might want to look into, we're happy to do that. We feel like that's one of the sort of things we contribute to this community. If you want to follow the neg reg, by the way, if you want to watch, you can watch via Zoom these days. If you want to see the materials that are being provided by the department to the negotiators, or if you want to review the materials that the negotiators themselves may be providing, all of that is posted on this website, the department's 2021-2022 neg reg page. It's kept updated, so it can be a lot to wade through. I will say this: if you are, if you work for a trade association and your job is to do this, great. If you're someone who is just terribly interested and you can't help yourself, I understand. If you have a limited amount of time, like many of us in this world, I would suggest, while it is worthwhile to pay attention to the draft language, the next real opportunity for you all as a community to have impact, I don't want to say the only opportunity, but for most folks, the next real opportunity will be to comment on the proposed rules. The other thing, all we are seeing at this point is draft rules, so we don't even know the extent to which the department is going to adhere to the language we're seeing when it puts out its proposed rule or not. The proposed rule will come out in the Federal Register. It will be the regulatory text they're actually suggesting become law. It will be accompanied by commentary. When that comes along, I think it's very important to pay attention and to review it, and if you see issues or have concerns, to comment. That's what the process is all about. So don't feel like you have to go to the neg reg page and look at every draft or suggestion or outline or proposal anybody makes. Some of these will never go anywhere, right? But if you wanted to, this is where it's all housed. And when those proposed rules do come along, there will also be a link to them in the final rules on this page. Now, some of you may be saying, boy, this is a lot to keep up with, and it seems to be kind of all over the place. Is there just some way we could organize our thinking? Well, guess what I have for you? An integrated rulemaking timeline. Not only that, but some of you may have noted that there's a pretty hot topic I had not mentioned thus far, and that is Title IX, and it also appears in this rulemaking, and I'll talk about it in just a second. But here's the integrated rulemaking timeline. April 6th, 2021, so that's when the department announced that it would be overhauling the Title IX regulations, which this administration is quite committed to doing. And you all, particularly if you've got residential or housing or athletics, but everybody, to be clear, not just those folks, but everybody, should really be paying attention to those regulations as well. May 26th, that's when the department first talked about all 14 issue areas, and then in August, here's our first rulemaking, right? October, it said there's a second one coming, and then October to December just ended. We had the first round of the ASL, we had all 3 rounds of the first neg reg, which was the ASL neg reg. December 8th, the department announced just last week the institutional program and automatic eligibility rulemaking, IEP. And then the department has also signaled that between January and March of next year, so I think we can, with a high level of confidence, know that these 3 rounds will occur between January and March of next year. So let's look into the crystal ball a little bit. And we consulted that fall agenda that came out last week when putting together this crystal ball. So my expectation is that I think this administration has a lot of talent. I think they have a lot of capacity. I'm sure they're all feeling overwhelmed all the time like we all are, but nonetheless, I think they have the ability to handle a lot of rulemaking at the same time. They clearly think that they do. So I am bullish on their ability to get through this agenda. Some things like our nominations may be compressed, right? So we just saw the 7 days that were allowed for nominations, but I think all of this is in the name of making sure that they get these rules through in the current 4-year term of President Biden. So I think in April 2022, first of all, the department signaled last week on Friday that they expect in April to issue their proposed Title IX regulations. Now, one thing I want to highlight is, and the reason you didn't see Title IX as part of all that discussion is because the Title IX rule is not subject to negotiated rulemaking, right? Under statute, any rules the department creates that concern the Title IV federal financial aid programs must go through negotiated rulemaking. They're one of only a couple of agencies, in fact, that are obligated to go through negotiated rulemaking, and easily the largest. But Title IX is not part of Title IV. In fact, it's Title IX of a totally different piece of legislation. It's not part of the Higher Education Act at all. And as a consequence, the department is not bound by that statutory requirement to go through the negotiated rulemaking process. So they are taking their time in a meaningful way, because I'm sure they know that this rule will be challenged in court and elsewhere. So they are trying to make sure that they give folks plenty of time to provide feedback, et cetera. I mean, when the Trump administration put out their proposed Title IX rule, they got 125,000 comments. So I have little doubt that this proposed rule will generate a similar kind of feedback. It's just such a highly politicized issue. But nonetheless, I think they're going to move forward with it, and they've committed to April of next year to get that proposed rule out. According to the fall unified agenda, they expect to get the ASL rulemaking proposed rule out by May of next year, and they expect to get the IPE proposed rule, right, and that's a neg reg that has not even occurred yet. They plan to get that rule out by July. So we're talking about 3 major proposed rulemaking packages in April, May, and July. To the other team members of the Thompson Coburn Higher Ed team who are listening, again, kiss your family goodbye, grab the pajamas for the office, because this is when we'll be doing a lot of reading. It also is when you should be doing a lot of reading, right? So I've got a line item here, 1, that is in bright red. And I have between April and September, so after these proposed rules come out, that's when the community really needs to be paying attention and commenting on the rules. And there is so much ground being covered that is important and meaningful and may have the potential of impacting all of you, regardless of what sector you might be in. I really encourage you, whether it's through us or others, to review these rules directly or to review secondary resources that talk about the rules, and to consider commenting, because that is how change is created to some extent. Now, the department has, they have to read the comments. They don't have to agree with the comments. They don't have to take them into consideration, but having them out there and on the record is important, and it also lays the groundwork if subsequently there are going to be challenges to those rules. October 2021 is when I anticipate the department will issue its final Title IX regulation, if not sooner. But I think it's going to get so many comments around Title IX that it will take a certain amount of time to review them. And also, there are a finite number of individuals there who can review comments and create regulation, even at the Department of Ed, right? It's not tens of thousands. It's scores of people. So they will need some time, particularly if they are orchestrating and moving through these other 2 rulemakings simultaneously. There is almost no doubt in my mind that they will do everything they can by November 1st of next year to get the final version of all their rules out, if they can, but at least the high priority ASL and IPE rules. So of those 14 topics being covered and negotiated, I think they will try to get the final version of rules for as many of them as possible out. But we have seen with prior administrations, including the preceding administration, the Trump administration, and we could see here that the department works more on a rolling basis. So they may say, we're going to do rulemaking packages for high priority concepts, and there may be 2 or 3 that we are less concerned with, that are not controversial, that we don't feel like we need to implement right away. And so maybe we'll put them on the back burner. We'll get these others out by November 1 to ensure that they can become effective the following year, and then we'll delay the remaining ones out for another year. So anything The department gets in place in final form by November 1st, as those of you who pay attention to these kinds of things know, can become effective by July 1 of the following year, pursuant to the master calendar requirement in the Higher Education Act. So I expect them to try to get everything they can out by November 1st. Midterm elections, November 8th, so just 7 days after that deadline. And that does change the dynamic. It doesn't necessarily stop the department, but they know that whatever they are doing, both in and outside the context of negotiated rulemaking, theoretically, if the Republicans took either the House or the Senate or both, the point is they could call folks from the department up onto the Hill to testify and to talk. They just have a lot more power to put pressure on the department if they don't like things that they are doing. So the midterm elections do have an impact on rulemaking, even if not direct, certainly indirect. January to June of 2023, any low priority items that were not issued in final form I would expect to be issued. July 1 of 2023 would be the effective date for the high priority ASL and IEP rules. I've had folks ask me many times over the last few months, am I correct in understanding, this is the question I get, am I correct in understanding that July 1, 2023 is the earliest new rules for the most part could become effective? For the most part, yes, that is correct. There could be some non-controversial technical rules that don't impact institutions of higher education, for example, that the department could unilaterally implement, but the types of rules you are probably concerned with that would impact institutions, it is almost certainly the case that July 1, 2023 is the earliest that they could become effective. July 1, 2024 would likely be the effective date for any low priority ASL or IEP rules that didn't make it out by November 1st, 2022. Right? And then November 5th, 2024 is our presidential election. So this is sort of your forward-looking rulemaking timeline. And things can always change, but my gut is that this is probably pretty accurate. So we'll see. I'm sure I should not have said that on a recorded webinar. Okay, and then finally I mentioned Title IX, just a little more on that. There are a couple of links here if you want to read up on it. It was announced, like I said, in April that this administration was going to redo the Trump administration's rule, significant rule. I think it was something like 800 or 1,000 pages when it came out in double-space format, that dealt with the management of allegations of sexual misconduct on campus. And then just last Friday, when the Unified Agenda came out, the department said, hey, originally we thought it would be like May of next year. Now we're backing it up a month. We think that we're going to get our proposed Title IX revisions out by April. I'm not going to spend a lot more time talking about Title IX during this webinar. There's just too much ground to cover, and that is such a massive topic, as those of you who deal with it know. But I will say this, just speculating here, doing a lot of speculating this afternoon, I think that it would surprise me if the department just threw out entirely the Trump administration's rule, and here's why. So despite, I think, sometimes what one might divine from the media and conversations around the Title IX rule, the Trump administration's rule was actually the first regulation that was put into place around the management of sexual misconduct allegations on campus in about 40 years, right? So in other words, the Title IX of the original Title IX Act came out in 1972. The department issued regulations in 75 for the first time that sort of dealt with the sexual misconduct issue. And there were no new regulations, no substantive new regulations on that topic under Title IX until the Trump administration's rule. So what that means is what the Obama administration was doing throughout that entire tenure, which was monumental. And I know there's been a lot of grumbling, and there are a lot of things that were complicated about the positions they took. On the whole, I have no doubt in my mind that it was absolutely for the better. You guys know I'm all about higher education. I've spent my entire career supporting higher education, but I certainly would concede that prior to the Obama administration's efforts, schools, it just wasn't a priority, and they weren't spending nearly as much time. I'm sure there are exceptions. But for the most part, when we thought about Title IX in 2005, we thought about equity in athletics, and that was it. And it wasn't until the the Obama administration really started issuing guidance and getting into the weeds and pushing schools that they started paying a lot of attention and building up their infrastructures and increasing their training and thinking about a lot of those types of things. And I think on the whole, that exercise was quite good. The challenge has been subsequently sort of getting into the weeds, because the bottom line is these types of incidents on campus are complicated. And you all know, if you manage this, I mean, they come in a million different varieties, right? And they're hard to deal with in real time, even if you are doing absolutely everything that you can possibly do to treat everybody equitably and to manage the situation. They're just difficult situations to handle. And so when legislators and regulators try to sort of get their hands into it and say, well, this is how we think it should work, or they can't contemplate every scenario. And inevitably, the frameworks they create for some are going to be problematic or not work. And that's just kind of where we are. And the Trump administration's rule, what's interesting was it was this voluminous rule. It is the first regulation that hit the books, and nobody really liked it, right? I mean, I think most schools found it burdensome and complex. A lot of consumer advocates felt like it was not as protective of victims or individuals who had experienced sexual misconduct as they would like it to have been, and they felt like it moved in a way that was not productive. At least for that community. So, nobody really liked it. But here's the giant clause. I wouldn't be a good lawyer if I didn't have one of those, right? It is still the first regulatory framework, really, that's been put on the books. And it does include a lot of basic concepts, like, the fact that you have to have certain types of proceedings and that you have to conduct them in certain ways. Rather than scrapping that wholesale, my expectation is that this administration will come in and tweak things. I mean, the tweaks may be significant, don't get me wrong, but it's sort of the difference between knocking a house down completely, right, and leaving the house up and gutting the inside. You know what I mean? I don't see this administration raising the lot, so to speak, and building a new house, because I think the house itself kind of makes sense. I think it's more likely what they do is they come in and they gut a bunch of the rooms. Not insignificant, right? Still a pretty significant makeover. But I think they'll leave a lot of the bones there, because I think the bones of the Trump rule probably still make sense in a lot of ways. So that's my expectation, but we'll see what happens. And, of course, I encourage all of you to review that rule when it comes out in its proposed form, supposedly in April. All right. Just a few additional machinations I wanted to touch on that speak to the regulatory environment and sort of what's happening, but are not actually part of rulemaking itself, right? So first of all, if you missed this, I think I said that was the last thing I was going to say about Title IX. All right, I lied. One more thing. So big announcement. In June 22nd of this year, 2021, the department issued a notice of interpretation explaining that it will enforce Title IX's prohibition on discrimination on the basis of sex, right, to include discrimination based on sexual orientation and gender. Now, first of all, I want to be clear, we're only talking about the federal level. Many of you already operate in states and municipalities that have long said, when we prohibit discrimination on the basis of sex, either that they've said that includes sexual orientation and gender, or they've just been explicit and said in their actual law, we prohibit discrimination on the basis of any of these things. But at the federal level, Title IX and most civil rights legislation that came out of the 70s didn't use these concepts of sexual orientation or gender. It just said we prohibit discrimination on the basis of sex. So there was this open question as to whether or not prohibiting discrimination on the basis of sex included discrimination on the basis of sexual orientation and gender identity. And, the Obama administration started taking that position, and we started seeing it at the EEOC and elsewhere, and some departmental guidance pop up, either in enforcement actions or guidance. There were a couple of pieces of legislation in the healthcare context where that concept was advanced. But it was not definitively determined by Congress or the Supreme Court of the United States in either the context of Title VII, which prohibits discrimination in employment, or Title IX, which prohibits discrimination on the basis of sex in programs and activities in institutions of higher education. Okay, so Bostock came along in 2020, and the Supreme Court said, at least in the context of Title VII, we think it is clear that discrimination on the basis of sex includes discrimination on the basis of sexual orientation and gender identity. But remember, this is in the midst of 2020. This is when the Trump administration is still in office. And the administration, the U.S. Department of Education, did not immediately come out and say, well, and the Supreme Court, by the way, took pains to say, look, we're just talking about Title VII. We've not made any decision with regard to Title IX, okay, or any other discrimination law. And the department, the Trump administration, didn't make any effort to say jump on that and start saying, well, we're going to apply this interpretation across, all these federal discrimination, federal laws that prohibit discrimination on the basis of sex. Well, this year, in June of 2021, they took that step. And this administration's Department of Ed said, the Office of Civil Rights said, we do interpret Bostock and that concept that's in Bostock to apply in the context of Title IX as well. So, my impression, candidly, is that most institutions of higher education already were taking this view, either because you're already required to by a state or municipality, or just because broadly, I think most institutions across all sectors didn't take issue with this all that much, frankly. But it now is the law of the land insofar as Title VII is concerned, and certainly the department has taken their stand on how they're going to interpret Bostock's application to Title IX. So if you weren't aware of this, please do be aware of it, and you may want to take this into account in the way that your policies are written or administered. Bar defense partial relief. So, the department, when it comes to bar defense, has two problems. And unfortunately, I think these get conflated and are impacting the negotiated rulemaking process significantly. The first problem is they've got tens of thousands of bar defense claims that are just sitting there that they have not been able to get through, right? And the Obama administration worked hard to make that claims process available, and they collected tens of thousands, and then they were gone before they could be adjudicated. The Trump administration adjudicated some. I think they wanted to adjudicate others in another way. There was lots of litigation that locked things up. People got very angry, and then they started adjudicating lots of them in ways that this administration doesn't like, et cetera. And now this administration, once again, is sitting on tens of thousands. Some were adjudicated previously by the Trump administration in a way they didn't like. Others have just never been adjudicated. Tens of thousands. So they've got this massive backlog that they're trying to contend with. At the same time, they are trying to think as to how they develop a process for the management of future claims. And those are really two very different issues, right? Because in the one case, the claims are already there, and I think the department's priority, particularly for those now at the department who are very consumer protection and debt relief oriented, is to just deal with that backlog as quickly as possible. On the other hand, on a go-forward basis, we have no idea who complaints are going to be made against which institutions and whether those complaints will have merit or not. And at least from my vantage point, the objective of the go-forward bar defense rule certainly should be to create an equitable and fair process with the ultimate goal being a just outcome. In other words, we want the process to work in a way that makes it as likely as possible that the department will get the right answer, right? Which I just think makes sense. But if you've got 200,000 bar defense claims sitting there, backlogged, most of which are in fact claims against schools that no longer exist, you might be tempted to develop a process that is more geared towards just discharging claims as rapidly as possible so you can get through the backlog. And I think both of those priorities have been very much part of the push and pull in the most recent negotiations. And I also think it's one of the reasons why, candidly, the bar defense framework that we have now is extraordinarily schizophrenic. We've got 4 different versions. We've got different rules for the standards and procedures that are supposed to apply to different loans depending on when they were originated or first dispersed. The latest version of the rule doesn't even attach to loans. It just has to do with when you file a claim. It is all over the place. I seriously question, and this is not being glib, I seriously question how many folks at the department on a go-forward basis would even be able to parse through all of this and administer it all in the correct way, even if they wanted to with the best intentions. And that has nothing to do with, I'm sure, the smartest of people. If you haven't dedicated your career to following this topic, I don't know how you could expect to keep up. It's become such a hornet's nest of regulation and policy. It's really a shame. The FTC press release, so if you are in the proprietary school sector, you probably caught this in October of this year. The FTC sent a notice out to 70 institutions saying, we're not saying anybody's done anything wrong, but if you do anything wrong, we're coming after you, which was interesting to say the least. And then not long after that, on October 8th, just a few days later, the department announced a new Office of Enforcement within federal student aid. There was an Office of Enforcement that was created under the Obama administration. I'm not sure it ever fully disappeared under the Trump administration, but I think this department is saying, not whether it was formally gone or not, it has been reconstituted in a way that is going to be far more active and more meaningful, right? And it's being led by Kristen Donna, former enforcement director of the CFPB. So she was not on my earlier slide, but just another example of someone whose prior experience is not, now I don't know her whole resume, so I apologize to Kristen if I'm speaking out of turn, but at least based on what I know of her prior regulatory experience, she's not an educator. This is not someone who came from a school or higher education, but someone whose background is enforcement, regulatory enforcement, and clearly very consumer focused, right? Okay, so we are to our secret word of the day. I will not say it out loud, but I invite you to take a look at that and again, hit the little radio button. I suppose maybe this is we're coming up on the holiday season when a lot of people partake in meats that they typically would not deal a great deal with. I have one downstairs. It is a spiral version of this particular meat, and it is also waiting to be honey glazed. I hope I did not give away too much. I don't know, the folks who administer the webcast may get mad at me. Okay, so moving right along. The ASL rulemaking, and I'm going to close this out with this because I think it's really important. So first of all, I mentioned to you that there were, 9 topics on the table, and I could not help myself. The department is always, they're big on scorecards, so I decided to create a consensus scorecard, and being the glib guy that I am, actually, if you go and look, this is actually the college scorecard background. Okay, so they were able to reach agreement on the topics that have a green check next to them, and they were not able to reach consensus, meaning all the negotiators did not agree on the topics where there is an X. And that's not entirely surprising. They were pretty close on several of them, actually. And, there's, as I'm sure you all know, when you're picking negotiators, there's an art to that. And I think all administrations, the Trump administration, the Biden administration, all of them are very thoughtful about picking negotiators that they think they will support the views put forward by the department, right? So it's not always surprising that they may be able to get to consensus or close to consensus on a topic where folks representing the same constituency under the prior administration voted no. And just by way of example, so one of the slots that is always filled at the negotiated rulemaking table is attorney generals. So under the Obama administration, the 2 attorney generals that were part of the bar defense to repayment rulemaking were from Massachusetts and California. And under the Trump administration, they were from Arizona and Texas. So it sort of gives you a sense as to how the selection of negotiators can come into play. But in this case, they were not able to get everybody across the line on several of the topics, including bar defense and close loan discharge, loan repayment plans, pre-dispute arbitration, and class action waiver clauses, and public service loan forgiveness. I think the one that was probably the biggest surprise to the department, not one I'm going to focus on today, but sort of from their perspective, I think they were really motivated and felt strongly about their income contingent repayment plan program that they were putting out. And surprisingly, this was not one where it was just one negotiator that voted no. It was actually 11 negotiators voted against the income contingent loan repayment plan proposal by the department. So I think they were pretty surprised by that, and it'll be interesting to see what they put forward, because when consensus is not reached, the department has the discretion essentially to go forward and do whatever it wants to do. So in other words, if all the negotiators come together and agree, the department is or pledges to adhere to whatever they all agreed to. But absent that agreement, the department says we're going to do what, if we can't get agreement, we're going to do what we think we ought to do. So anywhere you see an X, the department essentially is free to promulgate the rule, the proposed rule in whatever fashion, and the final rule in whatever fashion it would like. That having been said, I do think I'm a big believer in a negotiated rulemaking process. I don't think the sole purpose is to reach consensus. I do think it's an important opportunity for folks who are in the regulated community and really know some of these things to provide feedback to the department. I hear people complain periodically that, you know, so-and-so in D.C., the folks over there, they don't really know what it's like out here. And that may be true, and this is your opportunity to sit in a room or on a Zoom chat with 30 people from the department and explain to them. They may not agree with you or they may not take it into account, but at least you've got a shot to try to articulate your point of view. And so I always encourage folks to try to keep that in mind and take advantage of it. I want to spend the last little bit today focused on the department's proposals around the bar defense to repayment rule, or the draft language. So keep in mind, this is draft language. So this is not, I draw that distinction because what we're going to see next May is the proposed rule. Right now, all we've got is the draft language that the department put in front of the negotiators. But we do have that language, and we've reviewed it, and that gives you a pretty strong sense as to where the department is going. I am concerned that the bar defense framework here that has been proposed is highly problematic for institutions. I'm trying to be judicious here, right? But I really encourage you all in the regulated community, in all sectors, to pay close attention to what is happening and the proposal that's on the table. And, you know, part of, I think, the challenge with negotiating bar defense as part of this process is that it is unique, really, among the topics that typically are negotiated insofar as it is a very legal kind of process, right? It's a process for adjudicating claims of wrongdoing, which sounds a lot like what lawyers do and what courts do, right? Where many of the topics under consideration have nothing to do with that sort of adjudication claims type concept, right? I mean, when you're talking about loan forgiveness and Pell Grant thresholds and, you know, all those types of things, you certainly don't need a lawyer. I know most people feel like we could do with fewer lawyers in the world as a general rule. But in this case, when you're talking about concepts like statutes of limitations and evidentiary standards and materiality and harm, it would probably be helpful to have lawyers at the table because that's the kind of stuff that they deal in on a day-to-day basis. And there were very few attorneys at the table. And, you know, I don't necessarily fault the department for that because when you're dealing with 9 issue areas and only one of them really concerns an adjudication process, okay, I get it. Maybe you don't want to pick a whole bunch of attorneys who don't know anything about those other 8 areas. But the problem is when you get to that one process, it may be, and I'm speaking to you institutions of higher education, it may be that your negotiators at the table aren't as familiar with those concepts. And the crowd I'm really calling out here, or calling out to, are the attorneys on the line. Because, you know, if you're a lawyer or general counsel or assistant general counsel or compliance officer at an institution of higher education, some of these issues will resonate with you in a way that they may not resonate for your financial aid director or someone in the academic vertical at your institution. And by the way, the negotiators for much of institutions of higher education, who did a great job, by the way. I mean, I spoke with many of them. They are wonderful, smart, educated people who work very hard, and God bless them for being willing to sit through 3 weeks of negotiated rulemaking. I want to be very clear about that. But they weren't attorneys, and I'm not sure that some of these legal concepts necessarily are as meaningful to them, or some of the deficiencies I'm about to highlight are as meaningful to them as they would be to those of you who practice law for a living and will recognize procedural deficiencies and standard issues with standards as they are articulated. So what I'm really doing here, this is my, you know, little stump speech, but I'm asking those of you out there who are the attorneys and the general counsels and the compliance officers and have more familiarity with these concepts to please pay attention to this rule. And when the proposed version of it comes out, pay attention. And if you're not one of those people, when the proposed rule comes out, you know, but you do have a general counsel, put this in front of them and say, hey, does this look okay? Because my expectation is, as I go through the next few slides, whether you're an attorney or not, but certainly for the attorneys and compliance folks in the crowd, you'll pretty readily understand why there are some issues here. Okay, first of all, BDR retroactivity. So under the draft proposal, the department would apply the new standards that they are developing and processes. So all the new rule would become effective with the new rule and apply to any applications pending or filed after July 1, 2023, without regard to when the conduct that's the underlying the claim took place. So what that means is, if I graduated in 2010 and I decide that my school did me wrong in 2008, and I file my application January 1st, 2024, then the new rule will apply and all the new standards will apply, despite the fact that the conduct occurred in 2008, right? And I graduated years and years and years ago, right? So I just want to be real clear. They're not doing it. The prior administrations, both the Obama and the Trump administration, they said which process applies depends on when the loans were dispersed. So you tied it to the dispersal date of the loans. That's not how this administration is proposing to do it. What they're basically saying is anything that gets filed after July 1, 2023, right, we're going to treat under the new rules. And you say, well, and why is that such a big deal? Because what it means is today, right, as of right now, in 2008, if my school did something wrong and I didn't like it, and I graduated in 2010, breach of contract is not a basis for a bar defense claim. So if I filed a bar defense application today, I would have to show that it gave rise to a cause under state action under the very original version of the bar defense rule. If I file my application January 1, 2024, I can cite breach of contract because I now have access to the new standards. So conduct that is not illegal today will become illegal after July 1st, 2023, based on the way that they have proposed this. Those of you who are lawyers will recognize this as the retroactive application of law, making conduct that is illegal now, or legal now, illegal on a future date. And typically that type of thing is frowned upon, and it will be very interesting to see if the department sticks with this. But out of the gates, I think there is a serious retroactivity concern here. The department has also significantly expanded what constitutes a bar defense claim. So under the Trump administration, it's just misrepresentation, right? Under the Obama administration, it was misrepresentation, breach of contract, and if you actually had a judgment, right, from a court or tribunal. This administration, it's misrepresentation, omission of fact, breach of contract, aggressive or deceptive recruitment tactics, favorable judgment by a court or agency, sanction or adverse action by the department. So let me be clear. I'm going to talk about this in more detail in a minute. But in other words, if the department has sanctioned your institution, someone could file a bar defense claim. Say, well, my school got sanctioned, so I should get to discharge my loans, right? Sanction, adverse action, or corrective action by an accreditor. I love that one. So if you're a creditor, it doesn't even have to be adverse. Let's say you got a report from your creditor with recommendations and there was a corrective action requested or directed. Cause of action under state law. Okay, we're going to delve into a little of these. I'm not going to go into all of this in great detail. After the proposed rule comes out, I will. We will have a webinar or a webinar series, and we will break down the proposed rule and talk about what the department is actually proposing. This is based on the draft language, but I expect this is a pretty solid preview. So the department proposes, first of all, to use misrepresentation, the federal definition of misrepresentation, not the definition of substantial misrepresentation. Let me be very clear. Under current federal law, the Department of Education may not take action on an institution if it engages only in a misrepresentation. It has to engage in a substantial misrepresentation, which is a misrepresentation upon which someone has or could have reasonably relied to their detriment. So when the Obama administration created their version of bar defense, they tied it to this notion of substantial misrepresentation. The Trump administration created a separate concept for misrepresentation, but it also had elements of reliance and harm that were built in. This administration is saying if someone can simply establish that a misrepresentation occurred, that's a basis for a bar defense claim. Keep in mind, the department right now, again, cannot act on an institution if it strictly engages in a misrepresentation, because just because it's a misrepresentation doesn't mean anyone has relied upon it to their detriment. That's the definition of misrepresentation is strictly about whether the act or omission itself could have had a tendency to mislead, right? Doesn't have to be intentional, doesn't even have to be inaccurate. It's an extremely low bar, and that's why it's substantial misrepresentation in the law that is actionable by the department. This administration is using the definition of misrepresentation. I know I'm getting into the weeds, but this is a huge distinction, right? And again, it's more aggressive than what we saw from the Obama administration. None of the draft standards you saw on the prior slide, none of them, misrepresentation, breach of contract, none of them, right, require the department to determine that the borrower reasonably, or for that matter, actually relied on the act or omission of the institution, nor do they require the department to determine that the borrower suffered any harm. Let me say that again. Someone can establish a borrower defense claim without regard to which they actually relied on the act or omission of the institution or suffered any harm. In fact, under a proposed 685-48A, the department is required under the regulation to presume that a borrower was harmed by the misrepresentation in an amount equal to his or her entire loan. In other words, the full discharge amount, absent clear and convincing evidence to the contrary. And while the department has the option to consider that clear and convincing evidence, they're not required to do so, right? So again, someone could say the institution engaged in a misrepresentation, not a substantial misrepresentation, just a misrepresentation, right? I did not rely upon it. It did not harm me. But that would still be on its face sufficient to establish a borrower defense claim. Assuming the only other thing is it has to connect to, you know, the direct loan or the educational services provided by the institution. As articulated again, the draft standards would permit the granting of a full discharge even if the act or omission by the school was unintentional, the borrower did not rely upon the act or omission, and the buyer suffered no harm. The draft standard at 685-401, so this is, remember I mentioned there were two. There's one about the secretary sanctioning, and there's one about creditors, right? So under this draft standard, a borrower could establish a borrower defense claim, and the department could certify the claim and discharge the loan. If the secretary sanctioned or otherwise took adverse action against the institution at which the borrower enrolled. There is no definition of sanction or adverse action. There is no requirement that the sanction or adverse action was material to the institution or the borrower. There is no requirement that the conduct that gave rise to the sanction or misconduct was relied upon by the borrower, reasonably or otherwise, or even occurred while the borrower was enrolled, right? None of that is articulated in the standard. It just says if the secretary sanctioned or otherwise took adverse action, then someone on that basis alone can make a borrower defense claim, say I should get my loans discharged. There's also no requirement that the act or omission harm the borrower in any way. Similarly, there's another standard that goes to the accrediting agency, institutional or programmatic. It says, again, the department could certify a claim and discharge a loan if it were to determine that the institution's institutional or programmatic accrediting agency took corrective action, sanctioned, or otherwise took adverse action against the institution at which the borrower enrolled. It doesn't say the borrower, by the way, had to be in the program that's programmatically accredited. So theoretically, if the ABA, right, issues some letter requiring corrective action for your JD program, an engineering student at the university would have a basis for a borrower discharge. I'm not saying the department would grant it, but under the law, as it's written, they could. And so then, you know, the department, what you're going to hear if you raise this type of objection, I think, is folks saying, well, we would never do that. But my preference is not to rely on the good graces of the staffers who are considering these claims. My preference is to actually have a process in the law that is fair and equitable and builds in certain types of protections, right? Here, again, there's no definition of sanction, corrective action, or adverse action. There's no requirement that the sanction or action was material to the institution or borrower, that the conduct that gave rise to the sanction or action was reasonably relied upon by the borrower or harmed the borrower in any way. And there's no requirement that the conduct that gave rise to the sanction or action even related to the borrower, or in the case of a corrective action, whether the action was even adverse. Statutes and limitations. The draft language does not place any limit on when borrowers may bring claims, right? So just to be clear, I graduated in the 90s. I could bring a claim. And if I bring it after July 1, 2023, the new law would apply. So I could assert a breach of contract claim against my university or law school, despite the fact that I graduated, 25 years ago. Interestingly enough, and this goes to the conversation we had at the very beginning about the degree to which there are individuals at the department who are very focused on borrower relief. The draft language does propose that the department has to initiate a proceeding to collect from the school no later than 6 years after the borrower's last date of attendance. So if you're doing the math, what I'm saying is I could bring a claim even though I graduated 25 years ago, right? And if I do it January 1, 2024, it could ostensibly be under these new rules. But the department couldn't recover against my institution because we're way past this 6-year threshold. What it evidences is the degree to which the policy is not focused on really schools or even the taxpayer, right? Because if the department is discharging millions and millions of dollars for folks who graduated and for whom the act or omission occurred more than 6 years ago, they're not going to recover any of that. They're acknowledging that here. But it allows that debt relief that they're so focused on. It's interesting to me because I think, if you're a policymaker and you are more focused on, say, the taxpayer, you would never come up with a construct like this. What this suggests to me or evidences is an extreme focus on debt relief and consumer protection without a lot of concern, honestly, to even institutions. I mean, they're sort of saying, look, for all the schools, you're off the hook if it's more than 6 years, which is fascinating to me. Let's see. There we go. Individual proceedings. Again, I want to wrap it up here in the next couple of minutes, but as you would expect, the processes that are laid out are not great for schools. There are a lot of basic sort of fundamental issues. Just by way of example, for the individual proceedings, the individual process doesn't require that the department timely notify school that a claim has been filed. And, we've seen examples of schools that had multiple claims where they all get batched and sent to the school at the same time. And in some cases, some of those claims were filed years ago. So there's no obligation. The department could sit on claims and get to a critical mass and then send them all at once, right? Or to timely provide a copy of the claim. So there's nothing that says the department has to give it to you, with the result that the department could notify an institution weeks or months after a claim was received. Also, and I see this as just a fundamental due process failure, the proposed process doesn't require the department to identify or provide the institution the documentation obtained by the department or otherwise supplied by the borrower in support of the claim, or to identify or supply the records the department considers relevant to the claim. So in other words, you as an institution might have 30 days to respond to the claim, but you might not get a copy of the claim or might not have access to all of the documentation the department is referencing. And the department is explicitly authorized, and I think appropriately, to reference any documentation it has in-house that might be relevant to supporting the claim. But you as an institution should have access to that so you can understand what the department is relying upon and respond to it. There's also the group proceeding that's been resurrected here, highly problematic in my view. Probably not authorized by the statute, though, who wants to sue the department and go the distance is always a serious question. It would permit the department to proactively certify a group of borrowers and initiate a proceeding without any claim filed or any showing that a borrower relied upon or was harmed by some act or omission of the school. So just to be clear, let me say that again. If no claim has been filed, but the department is just driving down the street and sees an advertisement on the side of the road that it thinks is a misrepresentation, it could say, we think every student who's enrolled at that institution since that billboard went up was misled, and it could file unilaterally a borrower defense action without any of those students actually having filed a claim. And again, keep in mind, there's a presumption that they were all harmed, right? Because that's in the law. You presume that they were all harmed up to the amount of their loans. So there doesn't have to be a demonstration that anyone who went by was actually harmed. The department could sort of certify the class, you presume the harm, and proceed. The draft rule also permits a third-party requester to initiate a group process. This is new. And there's a rebuttable presumption that the department will form the group unless it's already done so. Third-party requesters are states' attorney generals and legal aid groups. So a legal aid group driving down the street could see a billboard and say, we think everybody who enrolled since that went up should get their loans discharged. And the department, under the law, there's a rebuttable presumption that they will, in fact, form that group and move forward with that claim. The draft proposes for adjudicating group claims in a process that's not unlike the one for individual claims, which means you have some of the same procedural deficiencies. The first two we talked about a minute ago. I'll just add the last two. It doesn't guarantee a school a specified time frame for providing response to any information from the department, and it doesn't guarantee the school will receive a copy of the official's written determination. I mean, there's literally nothing in the law that guarantees that schools will get a copy. Reconsideration, this may be, it's hard to pick, but this may be the most extraordinary piece here. A borrower may request reconsideration of a determination that's been made. So staffer's gone through all the evidence, all the procedure has taken place, and a determination has been made not to discharge the loan or to only provide partial relief. The borrower can request reconsideration based on administrative or technical errors, evidence that was not previously provided by the borrower, without regard to whether the new evidence is relevant to the matter, is likely to change the outcome of the prior adjudication, or is previously available to the borrower. Third-party requesters can also request reconsideration for similar reasons. So, and I think I've got, actually, let me go to the next slide here. I think it's similar information, but laid out a little differently. I think this will be better. So again, under the draft rule, a borrower can request reconsideration, administrative or technical errors. Consideration under a state standard in lieu of a federal standard, or evidence that was not previously provided by the borrower, right? And so again, that's without regard to the quality of that evidence or whether it was previously available or whether it's even relevant. That request by the borrower does have to be made within 90 days of the decision. The next slide is really the one that's so extraordinary, I think. Third-party requesters also can request reconsideration for similar reasons. So that state attorney general or a legal aid group, right, that qualifies, that is not a party to the claim, was not a party to the claim, that has already been fully adjudicated, can actually request reconsideration. And interestingly enough, while the borrower only has 90 days to request reconsideration, presently it does not appear to be any time limitation on a request from a third-party requester, with the result that it appears institutions would be required to defend bar defense claims conceivably decades after they were filed, many times over, and without regard to whether a prior adjudication had already determined responsibility. The secretary can reopen a borrower investigation anytime and many times over, so long as the secretary desires to consider evidence that was not considered in making the previous decision. It doesn't require that it be relevant without regard to whether it was previously available. And then finally, the draft rule does not even contemplate an opportunity for institutions to request reconsideration. All right, and here's your final secret word. And while you guys are filling this out, I'll just say, if you found that last little section to be bone-jarring, that was by design, right? And there's nothing made up there, all factual. But I have a real concern that, candidly, many in higher education aren't following this or entirely plugged in. And I'm all for a fair and equitable process that gives borrowers who were wronged an opportunity to seek the discharge of their loans. Not only do I think that's morally and ethically right, but it's clearly authorized by statute. There's no question that the department has the ability to create that process. I have serious concerns about a process that does not give institutions a fair shake. And it is my view that, and you can make your own judgment, but that this process is pretty far from that. So I hope that if you agree, and you may not, but if you agree, I hope you will pay attention to the proposed rule when it comes out and consider filing comments. All right, last little bit here. I'll go quick. We put out a lot of materials for you guys, and then let's do questions. I just want to highlight a couple of things. You know about the blog, hopefully. We're putting materials out there all the time. There's my colleague Scott Goldschmidt. He and Hope Watson did a nice presentation last month on summer camps. There's a checklist they put out recently that's on the blog. Like this seminar, we do lots of webinars on higher ed matters, and they're available on demand. So once these are done, we QA the video, and then it goes live and sticks around for a long time. So you can see, you can rewatch the summer camps webinar, and this one will be up shortly. We have a Title IX training series, and one of the reasons I wanted to put this up is because it sort of highlights that these laws continue to be in effect until new ones come along. You know, we're so focused on what's coming down the pike right now, but please keep in mind that there is a Title IX regulation that is in effect today with which you have to comply. Went into place last year, and it is voluminous and complex, along with a lot of other different laws and regulations I know you guys deal with. If you need help on the Title IX front, we did a 6-part series, and it's free and on demand on YouTube, and I'd be delighted for you to check that out. And then we are pretty routinely putting out compliance guides and white papers. We work really hard on these. I mean, we like to think pretty high quality, so this isn't just a two-page advertisement. These are serious documents. And these are 3 that we did this year. We updated our financial responsibility reporting guide, so this tells you what types of events you have to report to the department if they occur between audits. We did a white paper or guest guide on institutional loans and compliance considerations, a very tricky area. You start getting into the Truth in Lending Act and all the private education loan rules. And then finally, for the proprietary school sector, we did a guide on maintaining compliance with the evolving 90-10 rule. If you don't have any of these, or if you'd like one of them, please just give me the proverbial holler, and I will make sure that you get one. And with all of that having been said, here's the disclaimer. Just keep in mind, we're not your lawyers unless we're your lawyers. Now, let's look at some questions here. Right. I've got a couple that I see. I'll start, let's see. Is there anything coming out in the infrastructure bill that will be opportunities for higher education, especially in the skilled trades programs? You know, I mean, I do think that there are, there are definitely some concepts in the infrastructure bill and other pieces of legislation that have been percolating around. But this asker, if you want to call me on the side, we can get more into the legislative side of things. Like, so this presentation's really been focused on the regulatory front and what's going on over at the Department of Ed. But it is certainly the case that the department continues to threaten to reauthorize the Higher Education Act. Earlier this year we had the 90-10 legislation that prompted this rulemaking around 90-10, and there will continue to be lots of different pieces of legislation that get introduced that certainly will impact the regulatory environment. And it's important to note sometimes, and those of you who have been around a long time know this, sometimes the department will create a whole new regulation. Title IX is a great example where this could happen. And, they create a bunch of rules around Title IX. They revise the Trump administration's rule. They get it out the door next year. And then Congress reauthorizes the HEA. And in doing that, overhauls chunks of Title IX, which they could do. I know I said earlier Title IX is not part of the HEA. It's not. But in those negotiations on the Hill, the Democrats in particular have said, as part of reauthorizing the HEA, we want to rewrite some of Title IX. So they're sort of bundling it together. And that could happen right after a new rule comes along, and the department would have to go back and redo the rule again. And that happens and has occurred in the past. Let's see. October 2022 for Title IX, so there's a question mark. Yeah, I expect a proposed rule in April. That's what the department said last Friday. And then the question would be, October is how many months? May, June, July, August, September, so about 5-6 months. I think that may be enough time. When they issue the proposed rule, they'll usually give 60 to 90 days to comment. That's about 3 months. And then the question is, could they read those comments and issue their final rule in another 3 months? Doable. Again, this is a pretty talented and motivated department. So I think October's possible, but that's guesswork on my part, certainly, and they are juggling a lot of other, priorities at the same time, right? Let's see. Would a student be entitled or eligible for reimbursement for any debts paid in the case of institutional misrepresentation? Yeah, so the way bar defense works, if I'm understanding the question correctly, but just so that you know, the way bar defense works, if a student's loans are discharged, let's say their loans are on a 20-year term and they're 10 years in, so they've paid half of them off, they get that money back too, right? So the department cuts them a check, pays them back what they've already paid in, and then they also would be forgiven any amounts that remain if their full amount of their loan is discharged, right? And then the department reserves the right to turn around and go after the institution. So did I get that? Did I understand that the new rules will apply retroactively? So to be clear, we've talked about 14 different areas today that the department is currently, really 15 if you throw in Title IX, that the department is messing around with. I was just speaking, when I talked about retroactivity, I was speaking strictly about the department's proposal in its draft language for the bar defense claims process. I want to be real clear about that. There are 15 issue areas here. We could have literally thousands of pages of regulation to cover all 14, 15 of these areas. I was just focused on the draft that we saw for the bar defense rule. But what the department is saying is for the bar defense claims process, they're putting a new set of standards and procedures in place. And what they're saying is anyone who filed a claim after July 1, 2023, it would be adjudicated under the new standards and the new process without regard to when the act actually occurred that they're disputing. So just to put it in concrete terms, again, you know, if a student was enrolled at a school in 2008, and they're saying my school did something in 2008, and then I graduated in 2010 and went on, right? What that school did in 2008, in some instances today, as of this moment, is not illegal, and would not be a basis for a bar defense claim. And if a student filed a claim today, right now, there would be no basis for a bar defense claim. But if they filed that same claim after July 1st, 2023, conceivably that act or omission that occurred back in 2008 at that point would be illegal. And it is typically not considered okay to take conduct that is okay now and to make it illegal when it occurs and to make it illegal in the future. In other words, I'm drinking a cup of coffee right now out of a Yeti cup, right? If the department were to pass a law in 2 years that says anybody drinking coffee out of a Yeti cup has to go to prison for a year, it would not be fair to me then to apply that new rule to the conduct that occurred today, 2 years before that rule went into place. And that's what this rule is purporting to do. Even though it only is available for people who file claims after July 1, 2023, they could file a claim about conduct that occurred prior to that point. And that's what creates the retroactivity concern. Okay. Your chart says October 2021. Oh, it should, oh, no, so maybe I'm sorry, do I have a mistake on my chart for Title IX? I apologize. That does occasionally happen. Let me go back here, see if I can find it. Let's see if I've always wanted to figure out how to push back to one of my charts. Let me see if I have this right. See if that works. Okay. Yep, you're right. That was a mistake. So everything on this slide, my apologies. Thank you for calling that out. Everything in my family, I don't know those of you who have seen Christmas Vacation, but there is a scene in that movie, apropos, here we are December 14th, where Clark Griswold has just put up, you know, the 500,000 lights on the house, and his father-in-law stands next to him as the lights are shining in all their glory, and he says, "The little ones aren't twinkling, Clark." And there is a joke in my family, you know, whenever one little thing is off, and even if everything else is right, we say the little ones aren't. So here, the little ones aren't twinkling, Clark. You are correct. It should absolutely be October 2022. So I missed the little twinkling lights. I will correct this chart or correct this date and get it out on the wire here as soon as I can. I'll make sure that it's corrected in future versions of the presentation. But seriously, thank you for highlighting that. All right, well, I think that appears to be all of the questions. Sure appreciate everybody tuning in and sticking around with us. Very much look forward to bringing you guys further updates. Like I say, we expect to be producing a lot of content next year as all of these proposed rules come down the pike. And please, 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 if you have heard things today that concern you, think about doing comments to a proposed rule. If you're not an attorney type and you're not sure why these things might be problematic, but you've got an attorney type in your organization, highlight it for them. Ask them what they think. And if you ever want to talk to us, obviously we do draft comments for folks. The purpose of these is not to drum up business, but if you needed help or wanted to better understand what your comments might look like, certainly we are available to have that conversation. Thanks, everybody. Hey, we're not going to talk to you again until the other side of the holidays, so whatever you may celebrate over the next 2 to 3 weeks, we hope that you have a restful season and that you are able to spend time with those you love. Thanks, everybody, and we'll see you next time.